I'm Chris Moats, and this is Faith in Politics. On this broadcast, we range from the soul to the state as we cultivate those virtues and explore those principles that help us live well as faithful Catholics in this great land. Well, welcome back for another episode, folks. We are broadcasting from the great state of South Dakota once again, where under God the people will rule. It's starting to feel like fall around here, a little bit of a chill in the air. And I love it. We get to pull out the jeans and the flannel shirts and the sweaters. And, you know, I know the time at the lake is maybe drawn to a close, but I really do like fall. A great season. We also, as listeners to this broadcast will know, are remembering October as Respect Life Month. October is where we're taking the opportunity on this show to kind of walk through a different angle of the pro-life movement throughout each of our episodes in the month of October. Last week had a great conversation with Leslie Unruh, the founder of the Alpha Center. If you missed that episode, you can go back and take a listen. The Alpha Center is just a really wonderful pregnancy help center in the state of South Dakota. We're going to be kind of returning a little bit to that at the end of the month with the attorney that represents the Alpha Center. Gotten a number of questions from listeners. Hey, what's going on with this litigation that's at the Eighth Circuit right now? So we're going to unpack that litigation at the end of the month. In the meantime, we're going to kind of dive into some federal angles on the pro-life movement, talk a little bit about what's been happening under the Biden administration. Last couple of years, what was happening at Health and Human Services, EEOC, and more recently what's been happening in the new federal administration. Really excited to welcome to our program today Rachel Morrison. Rachel's an expert in this stuff. She's a policy analyst at the Ethics and Public Policy Center, where she works on their HHS Accountability Project. That's the Health and Human Services Accountability Project. As an attorney, her work is focused on religious liberty, healthcare rights of conscience, the right to life, non-discrimination, and civil rights, before joining the Ethics and Public Policy Center, where listeners of this broadcast, it's a think tank where you might recognize such big Catholic names as George Weigel, Roger Severino, Mary Hassan. Before joining that great organization, she served as an attorney, advisor, and special assistant to the General Counsel at the Equal Employment Opportunity Commission in the federal government. She focused on religious discrimination issues and was a member of their religious discrimination work group in the GC's office. Before that, litigation counsel at Americans United for Life and a constitutional law fellow at the Beckett Fund for Religious Liberty, defending the right to life, religious freedom for all. She has clerked on the U.S. Court of Federal Claims. Her legal analysis has been published in a number of great law reviews, Seton Hall, Pepperdine, Ave Maria, and elsewhere. She got her JD, Juris Doctorate degree, magna cum laude, from Pepperdine University School of Law. I could go on. It's just really excited to have you on the show. Thanks for joining us, Rachel.
Thanks, Chris. It's a pleasure to be here.
We're going to kind of jump into some really technical and complex stuff. And you're a lawyer. Can I ask you? I know you're a person of faith, and I know this is maybe out of left field because I didn't ask you this when we were talking on the phone the other day. I asked you about your faith a little bit, but now I'm just like, you've got this really just stunning resume as a lawyer. Can I ask what attracted you to the law when you were making that decision as a young person?
Well, I think when I was young, I liked to argue, so what appealed to me. My parents will appreciate that. But I think what attracted me to law eventually was that it combined different skills and talents I had. I studied math and speech communication in college, which is an unusual combination. When I got to college, there was so many options, and I wasn't sure if I wanted to go to law school or what I wanted to do, but I knew I liked math and solving problems, and I enjoyed speech and debate and arguing, so I did that as well. And then I think God just kind of used that, and then it came back together at the end of college, and I decided law school would be a great option, and I could use the skills and talents, critical thinking, problem solving, public speaking that I had studied, and it was actually a really good combination for law school.
That's great. So you probably liked those logic games on the LSAT, didn't you?
Yeah. That was my favorite section. I did those for fun, and I had to stop myself and study the other sections as well.
That's great. So I'm just delighted that you've chosen this profession. It's really important that people of faith and smart people enter it. So I know we've got some listeners right now that are either younger lawyers or in law school, thinking about law school. So what a great role model. Okay, let's get to it because there's a lot to talk about here. As we were kind of just prepping a little bit the other day and visiting about what do we talk about? There's so much happening at the federal level. One of the things that you mentioned was a recent action by the Federal Health and Human Services Department concerning the Title X program. I want to just unpack that a little bit. And so can you explain, maybe give a little bit of background if you need to, but explain what happened and why it's important, especially for pro-lifers?
So Title X is a federal program that provides federal financial assistance to healthcare organizations that provide voluntary family planning services. These projects provide a range of services that are acceptable and effective family planning methods, such as natural family planning methods, infertility services, contraception, services for adolescents, services for low-income individuals. But part of the Act is Section 1008, which prohibits all Title X funds from being used in programs where abortion is a method of family planning. And so Title X was created, but Congress decided that funds should not be used for abortion within the scope of Title X.
Yep.
But historically, Planned Parenthood has been a large recipient of Title X funds. And so they've been using grant monies for not for the abortion procedure itself, but to create this infrastructure and to support their other services. And as we know, money is fungible. And so they're using federal taxpayer dollars to then support their bottom line, which is abortion. So in 2019, under the Trump administration, HHS issued a new rule that required physical and financial separation between the Title X projects and the provision and promotion of abortion to ensure that the funds were not being used in places where abortion is a method of family planning, which obviously at Planned Parenthood, abortion is the primary method of family planning there. The rule also prohibited abortion referrals and before abortion counseling, like non-directive abortion counseling, which basically means that you can explain abortion, but you can't encourage someone to get it. But this non-directive counseling was required, which, as you can imagine, violated the conscience rights of other groups that do not support abortion. And so now this counseling was no longer required under this rule, and referrals were not required as well. As you can probably imagine, Planned Parenthood was not very happy about this because abortion is their number one priority. So they, along with several states, sued over this rule. Of note, one of the states was California, and leading the charge was then Attorney General Xavier Becerra. And if his name sounds familiar, it's because he is now the head of the Department of Health and Human Services. And so he's in charge of the agency that is now undoing these rules, and in charge of the agency that had all these rules that he sued over when he was in California. So there was lawsuits in Washington, Oregon, California, Maine, and Maryland. And thankfully, the law was upheld in Washington, Oregon, California, and Maine. In Maryland, the court said that the rule was enjoined or that it couldn't be enforced, like in Maryland specifically, but in the rest of the country, it was in effect. As a result, Planned Parenthood dropped out of the Title X program. So this was a significant step where Planned Parenthood chose abortion over their Title X clients, and they forego the federal funds because they didn't like the strings attached of not being able to counsel or refer for abortion in the Title X program. So this was a big win to help stop federal funds and taxpayer dollars from going towards Planned Parenthood.
So, and if I recall, it was to the tune of like $60 million. Is that correct? I mean, it's not a small amount of
sounds
money.
about right. It's been a while since I looked at the numbers, but I
Yeah.
think something around there. So it was a big step, a drop in the bucket for their entire budget, but every little bit helps. And so fast forward to 2021, we have President Biden and HHS Secretary Xavier Becerra. They proposed a new rule. This rule basically undid everything that the 2019 rule did. There's no more physical or financial separation between abortion services and Title X projects. This means that you could go in for Title X services and there can be a poster or a sign up for abortion, or you can be getting counseling for family planning, not abortion, in one room, and then right next door walk in and get an abortion. And so this separation is no longer required. As a side note, in the Maine case, Maine Family Planning sued over the rule, and they admitted in their court briefs that if they didn't receive Title X funds, they wouldn't be able to provide abortion, which is a direct admissal that they were using their Title X funding to support their abortion services. Because if they couldn't provide abortion but for those funds, then that means that they were violating the terms of using those funds to support their abortion services. So the 2021 rule takes away this physical and financial separation. They also require abortion counseling and referrals. And so there was a lot of public comments during the public comment period talking about how this is a violation of conscience rights, and people should not be required to counsel or refer for abortions. There was one footnote in the regulations that they added in that said there are federal conscience protection laws that might apply. No discussion of whether the counseling or referrals are not required if you have a conscience objection, or how HHS would evaluate a grant proposal if someone did have a conscience objection. They said in the kind of the explanation of the rule that providers can file complaints with the Office for Civil Rights at HHS. So basically, we won't tell you how these rules apply, but you can complain to us if we don't give you the grants because you won't comply with the abortion counseling and referrals. So that rule went into effect on Thursday.
So if I can maybe just give kind of a bottom line for that, is it seems that if we want to defund Planned Parenthood as sort of a political objective, keeping it from having access to these Title X dollars would be sort of a primary place, but which had been done previously, and we've just the present administration has completely reversed that. They're now funding Planned Parenthood again in what seems to be really a workaround to the Hyde Amendment. Is that a fair recap of what you've just told us?
So there's many different funding streams that Planned Parenthood gets from the federal government, Title X being one of them.
Yep.
And so the grants for the next year, the next cycle, haven't actually been given. So Planned Parenthood technically hasn't received new Title X funds.
Gotcha.
But now there's nothing stopping them from receiving those funds, and they were a big recipient before. And I misspoke slightly. I said the rule went into effect Thursday. It was published on Thursday.
Gotcha.
To go into effect 30 days. So November 8th, I believe it is. So that rule will go into effect if it's not sued by somebody to enjoin it or to stop it and a court agrees.
I mean, it really just seems a bit like, so this Xavier Becerra guy, who is the Attorney General of California, who on this show, I think we've called him before the nun suer. That's what he's kind of famous for. He sued nuns to try and make them provide abortifacients in their healthcare plans at their long-term care facilities that they're running. And I mean, it came up in his confirmation hearings. Unfortunately, he still got confirmed. But now he's just sort of undoing all the things that he was trying to, fight for as the Attorney General. Now he's in a position of power to undo it. Can we could probably talk about that for another, for the rest of the show, but there's some other stuff I want to cover. And there's something that's happening with separate payments. So with the Affordable Care Act, which colloquially is called Obamacare, going back, almost 10 years now, There, there was kind of, because we've got the Hyde Amendment, right? And I think people on the show will know by now that the Hyde Amendment keeps us from using federal dollars, be it, Medicare, et cetera, from funding abortions. So can you help us understand what was happening or is happening with insurer payments under the Affordable Care Act?
Yeah, so as everyone probably knows, there was a big fight over whether Obamacare, the ACA, should be passed. And part of the deal of passing Obamacare was that the plans would not be required to cover abortion. They could cover abortion, but they weren't required to. And another key element of that was that federal funds would not be used to pay for abortion that were prohibited under the Hyde Amendment. And so a key part of this provision was that issuers or insurers collect separate payments from individuals for their abortion services that for where federal funding is prohibited, and that they put those funds into separate allocation accounts. Under Obama, they said that separate payments meant that you could collect one bill as long as it was itemized, or if you just provided a notice at the beginning of the plan year that the plan covered abortion, or you could you could bill separately and then actually collect a separate payment. Under Trump, they said that a single combined bill is not single combined payment is not a separate payment, and so you needed to issue separate bills and receive separate payments. It couldn't be combined. This rule went into effect in 2019. Again, California, under now Secretary Becerra, sued to invalidate this rule, as did Planned Parenthood and other states as well. The rule was enjoined in court. It was appealed and in the middle of litigation, but come January 2021, administration shifted, and HHS now doesn't like this rule. They issued a rule a couple weeks ago that said that this, going back to the Obama rules, where a single combined payment satisfies this separate payment requirement, which blows my mind how a single, one payment means a separate payment. Yeah. Even if you itemize a bill, one payment is not a separate payment. And so this is the rule that goes into effect in 60 days. So end of November. And so yeah.
I was just going to say this. So this is, sometimes we don't even think about our health insurance. We just sort of pay the premium and we're happy to go to the doctor when we get sick. What is this? Why does this matter? Where's the rubber meet the road for, let's say, pro-lifers who are, on their employer's health plan, et cetera? Why does this matter particularly to us?
So the separate payment was important for a couple of reasons. One, for transparency, so that consumers know that their plan covers abortion. If they're having to pay a separate payment for abortion, they're going to realize that their plan covers abortion. If there's no separate payment, if there's just a notice in the middle of pages and pages and pages of plan documents that no one reads, you might not realize that your plan covers abortion, and you might be paying for abortion in violation of your conscience rights. The other benefit is accountability, that the funds are completely separate. They're not commingled at any point. If these funds are supposed to end up in separate accounts at the end of the day, it just makes more sense to keep it separate from the beginning and not mush the funds together and then try to separate it later. With this rule, individuals will be paying for abortion coverage in their plans without knowing it and in violation of their conscience rights.
Yeah. And I mean, I guess for myself as a consumer, that's something I would want to know. Does my plan, because if we're all paying into that risk pool, if we're, participants in the plan, we're all, potentially paying for things that are just really a huge burden upon my conscience. So yeah, great. Thanks for bringing that up. Before we spoke the other day, I wasn't even aware of that, but really important. One of the things that we've been talking about lately too in South Dakota have been state conscience protections, sort of putting a cause of action for a private individual in state law, so that, let's say, a nurse or a healthcare worker whose conscience has been violated, they've actually got recourse locally. And one of the arguments we've made is, hey, this is necessary because whatever protections are in place at the federal level, they're not going enforced. The cause of action doesn't belong to the individual. What can you tell us about what the current state of play is at the federal level? I know there's a headline about Vermont Hospital a couple of weeks ago. What's the update in that territory?
So the federal government, there's a number of federal conscience protection laws that are supposed to protect healthcare providers from having to participate in abortion or sterilization or providing contraception or various procedures that violate their conscience. These laws are tied to federal government funding. So if there's a violation, the remedy is the entity loses federal funding. And so, as you said, there's no private cause of action where an individual who's had their conscience rights violated can sue in federal court. It's up to the federal government to enforce this. So there was a case where a nurse at the University of Vermont Medical Center, or UVMMC, apparently Vermont is VM. I didn't realize that before. So at UVMMC, she had told her employer that she had a religious objection to providing abortion. But despite this known objection that she had, she was scheduled to perform an elective abortion. They misled her because they knew of her objection, that it was not actually an abortion procedure until she walked into the room. The doctor said, "Don't hate me," when she walks in. And in that moment, she had to make a decision of whether to participate in that abortion procedure against her religious beliefs or walk out, be accused of neglect of her patient, potentially lose her job or her medical license. And that's a decision that no one should ever have to make, especially on such a split moment and with a known religious objection. She ended up participating in the procedure, but as you can imagine, this was very traumatic. And so there was a complaint filed with the Office for Civil Rights at HHS. Under the Trump administration, they issued a notice of violation against UVMMC because they knowingly scheduled somebody with a religious objection to abortion to participate in the abortion procedure. Their regulations allowed scheduling in the case of allowed scheduling, kind of this like opt out where, oh, we'll try not to schedule people, but if we need to for patient care or something kind of amorphous like that, then it allowed them to schedule people with objections for these types of procedures, because the medical center wouldn't change their policies. DOJ sued in federal court to enforce this. However, again, in January 2021, there was a new administration, and so DOJ just quietly dismissed this lawsuit. There was no settlement, no agreement. They just reevaluated and thought that their policy didn't violate the conscience protection laws, and there was nothing for the nurse who was forced to go through this horrific situation. And so I will say that so it's unfortunate that the current administration doesn't seem as apt to enforce these conscience laws. But I will encourage individuals, if your conscience rights are violated, you should still file a complaint, because even if this administration doesn't go through or investigate, there's opportunities for a future administration that is more focused on enforcing these rights to go through and to do something. So as you said, there's no private right of action. So this nurse is unable to go to court to sue her employer for violating her conscience rights because HHS won't step in. And so that's why states, or even at the federal level, getting these private rights of action into the federal conscience laws are important.
Well, and I think it's important to note, too, that the Department of Justice quietly dismissed that suit at the request of, once again, Secretary Becerra, Health and Human Services, which is maybe a good place for us to to return to in the final couple minutes of our conversation, tell us what happened with this notice of violation that was issued against the state of California, and where that's gone.
So as you mentioned earlier, Becerra is known for trying to force nuns to provide abortion coverage. So there was a California law that required groups to provide insurance coverage for abortion. Obviously, numerous religious organizations didn't want to do that based on their religious beliefs. And so one of the groups that the California tried to force to include abortion coverage was a group of nuns. And so they filed a complaint with the Office for Civil Rights at HHS over this. Under the Trump administration, the Office for Civil Rights issued notice of violation to California. They actually issued for two different violations. And so so again, the enforcement mechanism is taking away federal funds for violations of these rights. And so the Centers for Medicaid and Medicare Services issued a disallowance of certain Medicaid funds as an enforcement mechanism for this violation. And this was Secretary Becerra specifically was this notice of violation and the disallowance was directed towards him as the top lawyer for the state of California. However, this disallowance was appealed, which was California's right, but with the change of administration, HHS under Secretary Becerra seemed to have a change of heart and withdrew the disallowance and decided that there actually was no violation of conscience laws, and that there was no violation for him, Becerra, to try to force nuns to provide abortion coverage. So as I think you can see, there's this ongoing theme of litigation and positions that Secretary Becerra took when he was AG of California that are now being affected at HHS under his direction. There seems to be a clear conflict of interest between his litigation positions in the past and his overseeing and implementation of rules and decisions at HHS.
I want to pause you right there, Rachel, because we've got one more thing I want to talk about, but I got to say goodbye to our radio listeners. We're at the end of our time. Thanks for tuning in. Until next time, live well. For our podcast listeners, we're going to keep talking here for just another minute because I think there's something else, and I don't mean to be just kind of spending our whole half hour picking on Mr. Becerra. But there's actually some very important things here that are worthy of our attention that we need to know about. What can you tell us, Rachel, about the Conscience and Religious Freedom Division at Health and Human Services? How did that come about and what's happening to it now?
So my EPPC colleague, Roger Severino, was actually the head of the Office for Civil Rights at HHS under Trump. Religious liberty and conscience rights are important civil rights. They're enshrined in law. The First Amendment protects religion. And so Roger created this Conscience and Religious Freedom Division as part of the Office for Civil Rights at HHS to focus specifically on these rights and to enforce protections under the law, which had been ignored in a lot of ways in prior administrations. And so the Conscience and Religious Freedom Division was the division that was involved in the Vermont case, that was involved in the issuing the disallowance of Medicaid funds for against Becerra in California for forcing nuns to provide abortion coverage. But once again, I sound like a broken record today. I think come January 2021 with Biden administration and Becerra as secretary, this division was folded into the Office for Civil Rights. So they're no longer, the career professionals who are experts on these laws are no longer working on these issues. They're not being consulted on any of these rules. They're just being informed about what's happening after the fact. And so they've basically eliminated it without officially eliminating it. And so it's really unfortunate that that they would want to get rid of the Conscience and Religious Freedom Division and ignore those rights and those protections that Americans have under law.
Well, thanks for giving that. And I maybe again sound a bit like a broken record, but the South Dakota Catholic Conference has really been encouraging some of our state policymakers to think about ways that they can put those protections and remedies in state law, because there's really a lack of confidence based on all this evidence that these really important rights, these fundamental human rights, are not going to have any relief at the federal level. So, Rachel, this has just been a great conversation. So grateful for your expertise. Thank you for being the watchdog on our behalf, holding, seeking accountability on these really important pro-life and other issues at the federal level. Thanks so much.
Thanks, Chris.
And thank you, as always, dear listeners, for tuning in. If you've got some feedback, if you like this show, if you got some ideas for future shows, don't hesitate to reach out. You can go to sdcatholicconference.org, click Contact Us. We'll be back for another pro-life episode in this Respect Life Month next week. We're going to be joined by Dale Barcher, the Executive Director of South Dakota Right to Life. Until then, live well.